Consumer Counterpoint, our vidcast talking about consumer issues related to class actions, mitigation of those risks. I'm Christine Argentine here in our Seifarth in our Chicago office.
And my name's Paul Ivanek, and I'm attorney in the Chicago office as well.
And today we're going to be talking another little piece about TCPA.
Right. So, TCPA, there's so many different issues that have been litigated over the years. Today we're going to talk about quiet hours and what we've been seeing in trends lately. And Christine, I guess to start, can you tell us a little bit about what quiet hours are?
Sure. So it's interesting because it's been a part of the TCPA for a long time, but this has been a brand new trend this year that we've seen. There's been hundreds of cases filed over quiet hours. Now, the regulations under the TCPA, under 64.1200, those are the regulations that the commission put in place. Part of those regulations are quiet hours, meaning, what hours can you send a telephone solicitation, a text message, a call, and what hours can't you? And under the TCPA, those hours are you shouldn't be sending telephone solicitations before 8 a.m. or after 9 p.m.
Okay. So do quiet hours fall under the TCPA itself, or you said regulations? So how does that play?
So under the TCPA statute, 227C,
right, gave
the FCC authority to put regulations in place. And these quiet hour regulations were put in place pursuant to that authority under 227C.
So it's like a broad authority.
That's right.
Okay, so the TCPA itself does not talk about any quiet hours specifically.
Correct.
Okay.
It basically gave the FCC authority to put in place rules that allowed or prevented residential subscribers from receiving telephone solicitations that were annoying to them, right? So the do not call list is also part of those same rules.
Okay. And so what do those requirements look like?
So again, the requirements for the quiet hours simply just say you cannot have a telephone solicitation, as that term is defined, before the hour of 8 a.m. or after the hour of 9 p.m., period.
And that's regardless of consent, or can there be a consent to receive those type of text messages?
So that's where this litigation kind of has started.
Okay.
Now, telephone solicitation is defined under those rules and regulations as well. And telephone solicitation excludes calls or texts to people who have given prior express permission or someone with an established business relationship.
Okay. So the statute provides for the consent, but then we see these regulations almost saying, because you said, there's no, between the certain hours, period. So there's kind of this conflict, it seems like.
Yeah, I think the way we see it on the defense side is it has to be a telephone solicitation, right? So if you have consent, if you have prior express permission, if you have an established business relationship, then that quiet hours provision technically should not apply.
So what does it look like from the plaintiff's perspective? Like, how are they bringing these claims? What are they arguing? And how are they combating against these defenses, it seems?
Yeah, so it's interesting because these cases have not been significantly litigated. They've been brought or threatened to be brought, and they've been settled, right? So we don't have any established case law interpreting, what telephone solicitation means with respect to quiet hours. But the argument is that the prior express permission is a limited consent, right?
Limited to within the hours.
That's right. So
regulations.
Even though a particular consumer gave you permission to text them marketing messages, they didn't give you permission to text them or to call them outside of those hours.
And how recent are the quiet hours regulations? How long ago were they put in place?
So those have been in place for years and years,
okay,
right? Those came with the original regulations under 227C. It's just that just this year, we started seeing these cases, again, hundreds of cases being filed. And it's interesting because it's opening the door, right? Because they're arguing that there is a limited consent. Now, all of a sudden, these plaintiffs can go after companies who believed they were in compliance by obtaining that prior express permission or having that established business relationship, but when they get these cases, that's, the argument is, well, you didn't have consent to text outside of these hours.
So it's almost like up until a year ago, all these plaintiffs believed that these companies were compliant because they had consent, and now with this new wave of quiet hours litigation, it's like, well, actually, no, you had this limited consent. Right. You're not really compliant.
Yeah, and it's become super challenging for businesses to deal with this issue, right? Because obviously the quiet hours are, and the way it's defined in the regulations is that it is specific to the local time of the recipient.
Oh.
Right? And so it's, if I'm in Chicago, right, my quiet hours are Central Time. But if the business that's texting me is on a different time zone, they have to be respecting my time zone, not theirs.
But you also travel a lot for work, so what does that look like?
Right, and so that's what's made it so challenging, because the question is, how do businesses define what time zone a particular phone is in, right? Do they use geolocation data to figure out, based on when they signed up, where was that phone registered or where was it pinging? Do they use area code? But obviously area code is problematic because people have cell phone numbers for a very long time. They move. Yeah. Their cell phone number still reflects Chicago, but maybe they live in California now.
Exactly.
Right. And then the point you just brought up, right? You have people who are traveling constantly, and businesses are sending these marketing campaigns out on a regular cadence, and they can't, nor do they know, if someone is in kind of their specific location.
Yeah, you're in Chicago and you're traveling to LA, and now all of a sudden you're 2 hours time change, right. and now what's compliance look like under that?
Right, and let's take a text message for instance, right? You as the consumer can show that you got a text message before 8 a.m. if you're in California,
right, versus
Chicago, and so you kind of have this violation even though typically you might be somewhere else.
Right. Like your 312 area code in Chicago, but you're going to say, well, I received in LA a 6 a.m. text message.
Right.
That's before 8 a.m. So that becomes a little tricky, it looks like.
Yeah, so it does make compliance really challenging, and I know businesses are really trying to figure out, well, okay, if we do have to comply, or if we want to mitigate against the risk of these particular lawsuits, how do we even do that, right? How do we even determine? And so what has happened is there's been petitions filed with the FCC to say, clarify, right, whether or not the quiet hours are only with respect to telephone solicitations, and clarify, like, how do we determine what someone's local time is?
Exactly. There's so many different ones, and so you can't be compliant with all of them because some of it would be impossible to do.
Right. That's right. So, the FCC in March got this petition. They put it out for public comment, which of course many different industry groups commented on both sides. And they haven't given an opinion yet.
Sure.
Right? But the interesting thing is that this type of issue, because it falls under 227C and the regulations, and the TCPA, right, it's not specifically in the statute language. This is also a topic that's kind of ripe for reevaluation after the Supreme Court decision that we talked about a few episodes ago. And whether or not courts need to go back and look at the statutory language and decide, is that express consent limited or is it not limited?
Sure.
Certainly under the statute, it's not written as a limited consent.
Yeah, because as we discussed in a prior episode, it just seemed like that decision opened the door for, hey, courts, start looking at each case and start interpreting the statute. Don't just assume that the regulations are exactly, the guidance, are more than guidance, they're binding precedent. No, they can be guidance, but the courts need to start doing more.
Right. So, it'll be interesting to see if the FCC does come out with an opinion about this, and whether or not that curtails some of these lawsuits. Sure. As I said, these lawsuits have not really even been making it to the motion to dismiss stage, the majority of them. It's primarily been one firm filing 95% of these lawsuits, and they seem to be settling these fairly quickly. But I think, if a court were to weigh in from the defense perspective, it feels pretty cut and dry, right? If you have it, if you're fitting within the definition of a telephone solicitation, or more importantly, not fitting within that definition because you have consent or you have an express business or established business relationship, then you don't necessarily have to worry about these quiet hours. Now, best practice, of course, you probably shouldn't be sending out marketing messages in the middle of the night after 9 p.m. before 8 a.m., right? That's definitely a best practice that we're advising. Sure. But whether or not it should be a violation, subjecting businesses to hundreds of thousands, millions of dollars in damages is a whole nother question.
Right. So we've previously talked about other state mini TCPA statutes. Do some of those states have a quiet hours requirement? Is it, are we seeing expressly in the statute, obviously, as opposed to regulations under the TCPA?
Yeah, it's interesting because almost all states have some telemarketing regulations, and a lot of them actually do have quiet hour provisions. Now, many of them use the same quiet hours as the TCPA.
Sure.
So if you're compliant with the TCPA, you're compliant with the states. But there are states that have different hours, right? So Texas is one of them. Florida is another one that have different hours than established under the TCPA. So you have to be particularly vigilant to make sure that, if the TCPA is 9 p.m., but then there's a state that's 8 p.m., right? That you got to make sure when you're texting people in that state that you're complying with that particular provision. And there's different states that regulate weekend hours, whereas the TCPA does not. Canada is another place that regulates different hours on the weekends. There's some states that say you can't send marketing messages on a federal holiday. So there is a lot of variation among the states in terms of even this very particular issue.
Yeah, so almost having that 50-state survey type, kind of just looking at seeing where does everything line up and where doesn't it, is probably going to be helpful for a lot of clients.
Right. Yeah, and we have a lot of companies that obviously are national in scope, right? Yeah. And we've talked about this before with respect to the TCPA and even other statutes. It's a real struggle figuring out how do we comply with the federal laws and all of the state laws when we have national campaigns that are going out to a database that includes people in many, many different states.
Right.
And do we take the most conservative approach and the most restrictive approach, or do we try to comply state by state? I mean, it's really difficult,
and it's tough because that's where you see a lot of like legal and business sides really kind of have push and pull on that too, because obviously the business side is trying to get out the marketing as most as they can, as opposed to legal saying, well, wait a minute, there's all these regulations and stuff, and there's not a lot of overlap in some of these, so it becomes tough.
It does. It creates a lot of tension, especially when you're talking about marketing and you're talking about, business growth.
Right.
There are different priorities, and so it does become difficult. But, we are continuing to work through this with our clients. Yep. I know, a lot of businesses are grappling with this, and so the TCPA has just become kind of a very hot button issue this year, given kind of the amendments to state statutes, given these new trends. So, we will obviously continue to talk about the TCPA and different state statutes as, throughout as we kind of progress through this vidcast.
Yeah, so I think it'll be interesting to see once we start getting these decisions. We'll provide another update just so we can see how the courts are attacking this quiet hours.
That's right.